In the early 1970s, a woman named Emily Card applied for a credit card through her bank. She had a job, a salary, and a solid financial record. The bank sent her a letter back saying that she could not have a card in her own name, but that if she wished for her husband to apply, he could. At the time, Card earned more money than her husband. It did not matter. The bank's policy was that women could not hold credit cards independently, and that policy was perfectly legal. Card's experience was not unusual. It was the standard experience of millions of American women in the early 1970s. A married woman who wanted a credit card had to apply in her husband's name. A single woman who wanted a car loan needed her father or brother to co-sign. A divorced woman who had spent 20 years building a household found that she had no credit history at all, because every account, every payment, every loan had been recorded under her former husband's name. When the marriage ended, her financial identity vanished with it. But this was not some relic from the 1800s. This was America in 1973. The country had already put a man on the moon, passed the Civil Rights Act, created Medicare, and built the interstate highway system. And a woman who earned a higher salary than her husband still could not get a credit card without his permission. The roots of the system went back centuries to an English legal doctrine called coverture. Under coverture, which was established in English common law during the medieval period, a married woman had no separate legal identity from her husband. The moment a woman married, her legal existence was absorbed into his. She could not own property in her own name, sign contracts, sue or be sued independently, or conduct any form of business without her husband's consent. Her legal existence was, in the language of the great English legal commentator William Blackstone, covered by her husband's identity. The husband and wife were one person in law, and that person was the husband. American colonies adopted coverture as part of the English common law they inherited, and the doctrine persisted in various forms for over 2 centuries. It shaped everything from who could own land to who could keep their own wages. A working woman's paycheck belonged to her husband by default. An inheritance left to a daughter became her husband's property the moment she married. The system was not designed to be cruel. It was designed to be orderly, in a world where the family was treated as a single economic unit, with the husband as its head. The first significant crack came in 1848, when New York passed the Married Woman's Property Act. The law established that a married woman was no longer automatically liable for her husband's debts, could enter contracts on her own behalf, could collect rents and receive inheritances in her own name, and could file lawsuits independently. The act became a model for similar legislation in other states over the following decades. By the early 20th century, most states had passed some version of a married woman's property law. But property rights and credit rights turned out to be very different things. Owning property meant holding an asset. Accessing credit meant being trusted to repay a debt. And the financial institutions that controlled access to credit had their own set of assumptions about women that no property law had touched. A woman might own her own house in 1950, but she could not get a mortgage to buy one without a male cosigner. She might earn a higher salary than her husband in 1960, but the bank would still require his signature before issuing her a credit card. The legal architecture of coverture had been dismantled on paper, but the financial institutions that controlled access to credit had never updated their practices. They continued to treat women as extensions of their husbands because no law told them they had to stop, and because the men who ran those banks genuinely believed that women were not capable of managing their own financial affairs. The problem became dramatically worse after World War II, when the consumer credit revolution transformed the American economy. Before the war, most Americans bought things with cash or saved until they could afford a purchase outright. Credit existed, but it was limited to wealthy borrowers and large transactions. After the war, everything changed. The Diners Club card appeared in 1950, followed by American Express in 1958, and Bank AmeriCard, later renamed Visa, in 1958. Installment plans for cars, furniture, and appliances became standard. Mortgages with low down payments made homeownership accessible to millions of returning veterans through the GI Bill. By the 1960s, credit had become the engine of American consumer life. You needed credit to buy a car. You needed credit to buy a house. You needed a credit history to rent an apartment in many cities. Employers in some industries checked credit histories before hiring. A good credit record was not just a financial convenience. It was becoming a form of economic citizenship, a prerequisite for participation in the modern American economy, and women were being systematically locked out of this new economic identity. The The credit revolution expanded access for men across every income level and every demographic, but it reinforced and even deepened the exclusion of women. The system assumed a world in which men earned money, managed finances, and held the economic power in every household. Women were expected to marry, support their husbands, raise children, and leave the financial decisions to the men who, the system assumed, understood money better than they did. Women were largely excluded from this revolution. Banks treated female applicants differently from male applicants at every stage of the process, and the discrimination was not subtle. It was systematic, documented, and openly defended by the banking industry as sound business practice. A single woman applying for a credit card would be asked whether she was planning to get married. If she said yes, or even if the bank simply assumed she might based on her age, the bank could deny her application on the reasoning that she would stop working after the wedding and would therefore be unable to repay. If she was of childbearing age, the bank might deny her on the assumption that she would eventually become pregnant and leave the workforce, regardless of her stated intentions. Some banks actually discounted a working woman's income by 50% when calculating her ability to repay a loan, on the assumption that she would eventually quit. A married woman who applied for credit was told that she needed her husband to co-sign the application, even if she was the primary earner in the household. Even if the husband was unemployed, incarcerated, or financially irresponsible, his signature was required because the bank's policy treated the husband as the creditworthy party by definition, and if she was approved, the credit history from that account would accrue to her husband, not to her. His financial reputation grew with every on-time payment she made. Hers remained invisible to the credit system. The consequences for women who found themselves suddenly single were devastating and immediate. A woman whose husband passed away might discover that she had no credit history, no credit score, and no ability to qualify for a loan of any kind, despite having spent decades managing the household finances and ensuring that every bill was paid on time. A divorced woman faced the same cruel paradox. The credit history she had helped build during her marriage belonged entirely to her ex-husband. She was starting from zero in the eyes of every bank and lender in the country, as if she had never participated in the financial system at all, and none of this was illegal. There was no federal law that prohibited banks from discriminating against applicants on the basis of sex or marital status. Banks were private businesses, and their lending criteria were considered proprietary decisions that the government had no authority to question or override. If a bank decided that single women were bad credit risks because they might get married, that was the bank's judgment call. If another bank decided that married women needed male cosigners regardless of income, employment, or repayment history, that was perfectly within its legal rights. The financial system was not broken in the way that something that has gone wrong is broken. It was functioning exactly as it had been designed to function, systematically and deliberately. And it was designed by men, for men, in an era when women were not expected to participate in economic life independently. The assumption that women could not be trusted with credit was not a bug in the system. It was a feature built into the foundations by people who genuinely believed that a woman's place was in the home and that her financial needs would always be handled by a husband. The legal groundwork for change began not with a law but with a lawsuit, and the attorney who argued it would go on to become one of the most consequential legal figures in American history. In 1971, a young law professor named Ruth Bader Ginsburg, working as a volunteer for the American Civil Liberties Union's Women's Rights Project, co-wrote a brief in a case called Reed versus Reed. The case involved an Idaho law that automatically gave preference to men over women when appointing administrators of a deceased person's estate. Sally Reed's teenaged son had passed away, and both Sally and her ex-husband applied to administer his small estate. The Idaho probate court appointed the father without considering any other factor, citing a state law that stated flatly that when multiple people of equal qualification applied, males must be preferred to females. The law was a relic, a leftover from an era when women were not considered capable of managing financial or legal affairs, but it was still on the books, and it was still being enforced. Ginsburg saw the case as an opportunity to establish a legal principle that had never been clearly articulated by the Supreme Court. She argued in her brief that this kind of automatic preference for men over women, based on nothing more than sex, violated the 14th Amendment's guarantee of equal protection under the law. The brief was meticulous, persuasive, and strategically designed to give the court a clear path to a ruling it had never made before. The Supreme Court agreed unanimously. In November of 1971, the court ruled that treating men and women differently under the law simply because of their sex was unconstitutional. It was the first time in the court's entire history that it had struck down a law on the grounds of sex discrimination. Chief Justice Warren Burger, writing for the court, declared that a classification based on sex that bore no rational relationship to a legitimate governmental interest violated the Equal Protection Clause. The Reed decision did not directly address credit discrimination. Nobody walked out of the Supreme Court building that day with a credit card they had been denied the day before. But the ruling established the constitutional principle that would make the Equal Credit Opportunity Act possible. If the government itself could not discriminate against women simply because of their sex, the argument followed logically that government-regulated industries, including the banking industry, should not be able to either. Ginsburg understood this chain of reasoning perfectly. She had designed her case to create exactly this kind of legal momentum, and the momentum was building from multiple directions at once. The legal foundation was in place. The public pressure was mounting. Now the question was whether Congress could turn moral outrage and constitutional precedent into enforceable law. By the early 1970s, the broader women's rights movement had turned financial discrimination into a national conversation. The National Organization for Women, the Women's Equity Action League, and dozens of other organizations were collecting testimony from women across the country who had been denied credit, mortgages, and business loans for no reason other than their sex. The stories were remarkably consistent. A female doctor was denied a credit card and told to have her husband apply. A female business owner could not get a loan to expand her company without a male co-signer who had no involvement in the business. A widow who had managed her family's finances for 30 years discovered that she was invisible to the credit system because every account had been in her husband's name. In May of 1972, these organizations secured hearings before the National Commission on Consumer Finance, a federal body that had been established to study the consumer credit industry and recommend reforms. For the first time, the evidence of systematic, industry-wide discrimination against women was presented to federal officials in a formal hearing room under oath with reporters in the gallery. The testimony was damning and consistent across every witness. Women from every state, every income level, and every profession told the same story. They were being denied credit not because they could not pay, not because they had poor financial records, but simply because they were women. The Commission's findings made national news and put Congress on notice. The problem was now documented, quantified, and supported by testimony from every region of the country. It was impossible to deny or dismiss. The only question left was whether Congress would act. If you're finding this valuable and want to see more deep dives into the hidden stories that shaped America, hit that subscribe button. We cover the financial history behind the systems and institutions you deal with every single day. Now let me tell you about the women who turned that legal principle into an actual law. New York Democratic Representative Bella Abzug, one of the most outspoken feminists in Congress and a woman who wore signature wide-brimmed hats that made her impossible to miss on the House floor, introduced the first version of an Equal Credit Opportunity Bill in May of 1972. Abzug was passionate, relentless, and fearless in her advocacy. But she was not on the House Banking and Currency Committee, which meant her bill had to be referred to and approved by a committee she had no direct influence over. The committee's chair, Representative Leonore Sullivan of Missouri, was the senior woman on the committee, but had a complicated relationship with the feminist movement and was not inclined to prioritize Abzug's bill. The legislation stalled in committee and never reached the floor for a vote. Abzug reintroduced the bill at the start of the next Congress in 1973. This time it attracted broader support, but it still faced the same institutional obstacle. Without a champion on the banking committee itself, the bill had no path to the floor. The breakthrough would have to come from inside the committee, not outside it. Meanwhile, Emily Card, the woman who had been denied a credit card despite earning more than her husband, had channeled her frustration into action that would prove more legislatively effective than any protest march. She got a job in Washington as a legislative fellow working for Senator William Brock, a Republican from Tennessee who sat on the Senate Banking Committee. Card used her position to research credit discrimination, draft legislative language, and build support for a Senate version of the bill. She essentially wrote the framework for what would become the Equal Credit Opportunity Act from inside a Republican senator's office, turning a personal humiliation into federal law. On the House side, the key figure was Margaret Heckler, a Republican congresswoman from Massachusetts. Heckler was a lawyer who had arrived in Congress in 1967 and immediately discovered something remarkable. As a sitting member of the United States Congress, she had no right to credit in her own name. A woman who had been elected to the highest legislative body in the world could not get a credit card without her husband's signature. Heckler joined the House Banking and Currency Committee with a specific mission. She was going to change the law. Heckler arranged meetings with the chief executives of several major banks, including representatives from institutions like Chase Manhattan and Wells Fargo, to discuss their lending practices. The meetings were revealing. The bankers told Heckler with apparent sincerity that they were concerned women would not repay their debts. They cited no data to support this claim. They had no studies showing that women defaulted at higher rates than men. Their concern was based entirely on assumption, tradition, and the unexamined belief that women were not serious financial actors. Heckler pointed out, with the controlled patience of a lawyer who knows she is right, that banks could approve or deny female applicants based on exactly the same creditworthiness criteria they used for men: income, employment history, existing debt, payment record. The issue was not whether women were good credit risks. The data, when anyone bothered to look at it, suggested they were at least as reliable as men. The issue was that banks were not even evaluating women as individuals. They were dismissing them as a category before the evaluation even began. Heckler drafted the House version of the Equal Credit Opportunity Act, but the bill's final passage involved one of the most elegantly executed political maneuvers in congressional history, and it came from a congresswoman who had been in office for less than 2 years. Lindy Boggs was a Democrat from Louisiana who had won a special election in March of 1973 to fill the seat left vacant when her husband, House Majority Leader Hale Boggs, went missing during a flight over Alaska. Boggs was a seasoned political operator who understood how Washington worked, but she was new to the Banking and Currency Committee. When the committee was marking up the credit bill, preparing the final text for a vote, Boggs noticed something that her male colleagues had apparently overlooked. The draft did not include the words sex or marital status among the categories protected from discrimination. Boggs quietly took the draft to the copy machine, added the 2 critical words herself, made copies for every member of the committee, and returned to the meeting. As she distributed the revised pages, she said with a smile that masked the sharpness of what she was doing, "Knowing the members of this committee as well as I do, I am sure it was just an oversight that we didn't have sex or marital status included. I've taken care of that, and I trust it meets with the committee's approval." The committee approved her addition unanimously. Nobody objected. Nobody could object because Boggs had framed her amendment not as a demand, but as a correction of an obvious oversight. To vote against it would have been to admit that the committee had intentionally excluded women from a bill about credit discrimination, which no member wanted on the record. The bill moved through both chambers of Congress with bipartisan support that would be almost unimaginable in today's political environment. The House passed it, the Senate passed it, the Conference Committee reconciled the 2 versions. On October 28, 1974, President Gerald Ford signed the Equal Credit Opportunity Act into law at the White House. Only 16 women served in the House of Representatives at the time. None served in the Senate. The law that ended sex-based credit discrimination had been written, championed, and steered to passage by a handful of women operating within a legislative body that was overwhelmingly male. The new law prohibited any creditor from discriminating against any credit applicant on the basis of sex or marital status. Banks could no longer require male co-signers for female applicants. They could no longer ask women about their marital plans or reproductive intentions as part of a credit evaluation. They could no longer discount a woman's income or refuse to consider her earnings when calculating creditworthiness. They could no longer file a woman's credit history under her husband's name. For the first time in American history, a woman's creditworthiness was to be evaluated on exactly the same basis as a man's, using the same criteria, the same standards, and the same process. In 1976, Congress amended the ECOA to extend its protections further, prohibiting discrimination based on race, color, religion, national origin, age, and receipt of public assistance benefits. The amendment transformed what had begun as a women's rights bill into a comprehensive anti-discrimination statute that covered every American who applied for credit, regardless of who they were or where they came from. The law did not eliminate credit discrimination overnight. Banks had spent decades building institutional practices around the assumption that women were secondary financial actors, and changing those practices required constant enforcement, legal challenges, and cultural pressure. Some banks dragged their feet. Some found ways to comply with the letter of the law while violating its spirit. Loan officers who had spent their entire careers denying women credit did not suddenly become champions of equal access just because a law told them to. But the ECOA gave women something they had never had before in the history of American banking: legal recourse. For the first time, a woman who was denied credit because of her sex could file a complaint, hire a lawyer, take the bank to court, and win. The law provided for actual damages, punitive damages up to $10,000 per individual, and $500,000 in class action suits. Banks that discriminated now face real financial consequences for the first time. In the mid-1970s, a wave of women's banks opened across the country, institutions founded specifically to serve female customers and to demonstrate that lending to women was not the risky proposition the established banks had claimed it was. The first Women's Bank of New York opened on Madison Avenue in October of 1975 with enormous public attention and long lines of women waiting to open accounts on the first day. The bank made a point of evaluating every applicant, male or female, on the same criteria. Similar women's banks opened in Richmond, Los Angeles, San Diego, Denver, and other cities, each one serving as both a practical financial institution and a visible symbol of women's economic independence. The established banks noticed something interesting in the years that followed. Women who had been denied credit for decades turned out to be excellent customers. They repaid loans at rates that matched or exceeded men's repayment rates. They maintained accounts responsibly. They were, in short, exactly the creditworthy borrowers that the data had always suggested they would be, if anyone had bothered to look. The story of women and credit in America is a story about a system that functioned exactly as it was designed to function, right up until the moment when the people it excluded decided they had waited long enough. For nearly 2 centuries, the financial system treated women as dependents, appendages of their husbands, economic minors who needed male permission to participate in the basic transactions of modern life. That system was not an accident or an oversight. It was built on legal doctrines that were centuries old, reinforced by institutional practices that nobody in power had any incentive to change, and maintained by the simple fact that the people making the lending decisions and the people writing the laws were, with very few exceptions, men who had never personally experienced what it felt like to be told that their money was not good enough because of their sex. It took a constitutional ruling that established sex discrimination as a violation of equal protection. It took a consumer rights movement that documented the scope of the problem with thousands of letters from women who had been humiliated by their own banks. It took a woman who turned a personal rejection letter from a credit card company into federal legislation. It took a congresswoman who drafted the law because she herself, a sitting member of the United States Congress, could not get credit in her own name. And it took another congresswoman who walked into a committee markup, noticed that the men in the room had forgotten to include women in a bill about credit discrimination, and fixed the problem herself with 2 words and a smile that dared anyone to object. Emily Card got her credit card. Margaret Heckler got her law. Lindy Boggs got her 2 words into the statute. And 50 years later, any American over the age of 18 can walk into a bank and apply for a credit card based solely on their credit history, regardless of whether they are male or female, married or single, widowed or divorced. That right is younger than the pocket calculator. It is younger than Star Wars. It is younger than most of the people reading the credit card statements that arrive in their mailboxes every month. And for nearly 2 centuries before it existed, the answer to the question of whether a woman could borrow money in her own name depended entirely on whether a man was willing to sign his name next to hers.